It is not probation's job to try to force you to do what you got an excellent opportunity to be able to do instead of going to prison. It's not their job. You're not a child. They don't need to drag you along by your hand to do what you're supposed to do. And it sounds like you've done okay on probation, but it's only because they've threatened sanctions. So, Mr. Norman, you're on probation for the third-degree felony offense of assault family violence by impeding breath or circulation. Looks like you were placed on that probation back in 2021, and that was a 4-year deferred probation. And I received an administrative hearing that shows it looks like you're behind in your court assessed fees and you failed to report as directed on June 6th. And the probation officer made some recommendations. And that was going to be for you to serve 15 days in the Jefferson County Jail, be placed on the high medium caseload, some other things. And instead of doing that, I wanted to bring you here because obviously that any violation is not tolerated, but it looks like if I wanted to know more, if you only didn't report one time and you're behind in your fees, are you working?
Yeah, I'm still working.
I'm sorry. Okay. Where you work?
Optimus Steel.
Say it again.
Optimus Steel.
Okay. Why didn't you report on June 6th? Do you remember?
June 6th, I was supposed to report. It was June 4th that I missed.
June 4th, right? Because that's the hearing date.
Yeah.
So it wouldn't have been the day after. That's another reason why this was a little confusing.
Because what it was, I was supposed to say June 6th. They sent the letter. I thought that was for me to report for June 6th. And when I got in touch with her, she said I missed the administrative hearing. I said, no, I'm supposed to see you June 6th. She said, no, it's for June 4th.
Okay. So why are you behind in your fees if you're working?
Well, I was helping my kids and getting caught back up.
You were doing what? I'm
I
sorry.
was helping my children.
Okay.
But I'm in the process of getting caught back up now.
So here's the thing. If you have a job and you have the ability to pay, then you can do everything else right on your probation. And at the end of your probation, which is only 1 year away, you could still be revoked. You could be convicted of this offense and you could still go to prison for not paying if I find that you could have paid and you didn't. So it looks like you've done most everything else from what I can tell very well. This is the first administrative hearing, but I do want you to understand it's very important that you get caught up on those fees. If you start making payments and you're not caught up by sometime next year, then what can happen is we extend it and you can be on probation longer. It's not meant to be a punishment. It's just meant for you to be able to finish paying, right?
So I was trying to be finished by August.
Well, then it sounds like you need to get to paying some money.
No, I mean, because I got it so far ahead to I forget to pay it off in August.
Okay, so here's what happens.
But I think I'm at 2200.
Yeah, so here's what happens. If you get all your money paid off ahead, it's not automatic that you get off your probation early. Okay, so a lot of people do get terminated off their probation early if they do everything satisfactorily. So I'm not saying that you're not going to, but obviously getting your fees caught up and paid in full makes it look a little better when you go to probation and say, hey, would you consider sending something over to the judge for me to get off early? But you have to be following all the rules, take care of everything that you're supposed to. Do you understand? Is there any other issues that I'm missing?
So I've spoken to his previous officer, and she said since the beginning of his probation, it's kind of been, we've been trying to get something out of him to want to be successful. Since the beginning, he's kind of already said his attorney had told him that he could get off in a third of his time if he just paid his money. He had another admin summons prior in 22, and it turned into a case staffing. He hadn't done any of his programs and conditions at that point. We had to pull it out of him to be able to do it. At this point, he's always kind of been nonchalant about probation. Even in his initial PSI, it even said that his nonchalant behavior could be a downfall for his probation.
Okay.
So this was kind of for us to see what you would like us kind of to do when it comes to that, since he's just been very nonchalant. It's when we enforce action or try and do a sanction is when he actually wants to do it. Because before I started making all the payments, he had told me, I'll get to it. It'll be done at some point. I promise it'll be done at some point.
So
very nonchalant.
here's what we're going to do, Mr. Norman. It is not probation's job to try to force you to do what you got an excellent opportunity to be able to do instead of going to prison. It's not their job. You're not a child. They don't need to drag you along by your hand to do what you're supposed to do. And it sounds like you've done okay on probation, but it's only because they've threatened sanctions. So here's what we're going to do. There's no more them threatening any sanctions. You show up when you're supposed to show up. You pay what you're supposed to pay. Maybe you get off early. Maybe you don't. We'll see. But if you don't do what you're supposed to do, it's not going to be in another administrative hearing where they say, hey, we're going to ask for 15 days in jail, or, we're going to try to get your attention. Today's attention getting day. If you don't do what you're supposed to do, there's going to be a motion to revoke filed and you're going to end up in prison. It's just that simple. Do you understand? Do you have any questions about that? All right. Thank you. Morning, sir. Are you Ray Francis Jr.?
Yes, ma'am.
And Mr. Francis is charged with failure to comply with sex offender registration requirements. And Mr. Lewis, what's the announcement?
Well, Judge, I have gotten access to discovery and everything, but I do need a little time to get Mr. Francis in so we can go over it. I think by the next setting, we should be able to make an announcement.
Any issues?
Judge.
So, Mr. Francis, I'm going to reset your case about 30 days or so. Make sure you make an appointment to go visit with Mr. Lewis so y'all can go over all of the discovery that he's received, and we'll get an announcement at the next court date. All right, you're free to go. And Mr. Lewis, you have Zabaras Harrison, cause number 23 DCCR 1410. Good morning. I'm good. Are you Zabaras Harrison?
Yes, ma'am.
Why didn't you go for your PSI? I'm sorry?
I thought I was just waiting. I might have. I misunderstood that, I guess.
You misunderstood what? So let me ask you this. When you were here and you entered your plea of guilty, were you on bond or were you in jail that day?
I was in jail.
You were in jail, and so I let you out of jail that day, right?
You got me a bond. You loaded my bond.
Yeah, and I said some very specific things to you because I say them to every single person that I do that, right? Do you remember that?
Yes, ma'am.
Maybe I said that if you don't go to the probation department and take care of that pre-sentence report, that when you come back, you run the risk of me not accepting your plea agreement and things could be much worse. Do those words sound familiar?
I might have misunderstood you. I thought I was waiting to get back here to see what.
Before you left that day, you sat in that jury box and the probation officer talked to you and handed you some papers and said, when you're released, come here. And they gave you the address and everything.
No, that didn't happen.
That did not happen.
No.
That would surprise me because that is what we do in every single case.
Yes, ma'am. It didn't happen.
So, but I told you to go to probation. I know I did because I'd never not say it. Never.
We signed for what I was going to get.
Mm-hmm.
You told me that you wanted to do you
Precinct.
wanted to take some more time with looking over things.
That I wanted to reset your case to get a pre-sentence report done. Okay. And that I told you have to go to probation. And I told you if you get arrested for anything.
Right. You told me you put me on the monitor and
Mm-hmm.
everything.
Yeah, I told you all that.
I didn't. I'm up.
If I test you today, you can have anything in your system?
No.
Have a seat. Let's double check that before I decide what to do.
No.
Pageant, you have Justin Living, 24 DCCR 0288. Good morning. Are you Justin Living? And Mr. Living's charged with credit or debit card abuse. And what is the announcement?
Your Honor, I've received all the discovery on this case, and Mr. Living missed an appointment with me in May, and we have not been able to communicate since then. And my understanding is he also has a burglary of a habitation case.
He was indicted 4 weeks ago, Your Honor.
So,
Okay.
I'm going with that.
Okay. So here's, do we have that? If it was indicted a month ago, we should have it. But here's what I'll do. Mr. Living, obviously you need to hire either Mr. Pageant or someone on that new case. And I'm going to just do a reset for
Well, Your
30.
Honor, I do have a concern about his bond situation.
I don't even have it.
and I'm not sure what it is either, to be honest with you.
I can tell the court, he made a $5,000 bond on March 24th of 2024 in the state jail in the state jail case, which is the fraudulent use or possession of a debit card,
Uh-huh,
which is also enhanced to a third degree.
okay.
That is
About
my
2 weeks later is the offense date on this burglary, which he made a $20,000 bond on April 7th of 24.
You have the cause number?
24 DCCR 1100.
Oh, it's on the initial docket.
And that, Your Honor, he has one prior TDC felony, so that's enhanced to a first degree.
Are there, can I tell from this what conditions, where can I look to find the conditions? Hold on. Let me find it first.
And there is an arrest in the meantime for an assault family violence case, a felony, but that has been refused.
Okay. Where's the bond? What do you mean? Go to the bond page. So it would be, oh, here. Yes, ma'am. Okay. So it doesn't show any specific conditions. Let me look at the,
I can look in the jail screen and see.
double check if you see anything there while I look at this, something else. Pending.
My understanding is he may have 2 misdemeanors pending, Your Honor.
It's criminal justice and DWI. They're in.
Until she asked him. And I'm not representing him on those 2 either. I wasn't.
Penalties on those.
Okay. Let me ask you this, Mr. Living. If I test you this morning, what's going to be in your system? Nothing? Let's double check that. Have a seat in the jury box and then we'll, might make at least some conditions, modifications on that bond.
Sounds good.
Mr. Wilkerson, you have Elijah Miller sentencing, cause number 23 DCCR 0402 and 0403. Good morning. Are you Elijah Miller?
Yes, ma'am.
Mr. Miller, you were previously here, entered a plea of guilty to the state jail felony offense of burglary of a building, and I've received a copy of your pre-sentence report. Has everyone had an opportunity to review that report?
Yes. Yes.
I want to know that you're on probation in Orange.
Yes,
Have they filed a motion to revoke your probation because of this case?
no, they told me that, because they happened like right at the same time, that, this, would not affect it.
Your probation started after this. Okay, all right. Any corrections or objections to the pre-sentence report?
Nothing from the defense. Not from the state.
All right, Mr. Miller, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of burglary of a building. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but I'm going to probate that. You'll be on probation for 5 years. You're ordered to pay a $500 fine to follow all of the rules and conditions of probation. If you do that, then for all practical purposes, your case here in court is over and you'll be able to serve that 2-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you could be facing that 2-year sentence that you've agreed to. Do you understand?
Yes, ma'am.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition, excuse me. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Wilkerson. If you'll just have a seat here in the courtroom, probation will call you up when she's ready to go over your paperwork, and I will sign a dismissal as part of this plea agreement in clause number 23 DCCR 0402. All right, good luck to you, sir.
Thank you.
Mr. West, on Leonard Guillory sentencing in clause number 22-40982. All right, sir, you Leonard Guillory,
Yes, ma'am.
and Mr. Guillory was previously in court, entered a plea of guilty to unlawful possession of a firearm by a felon. I received a copy of the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, sir.
State head judge,
Any additions or corrections?
None from the defense, Your Honor.
none from the state judge.
What is the status of, did you go to Liberty County last week?
Yes, ma'am.
And what's the status of that
Well,
case?
I had tickets and I have a court case that reset it to September 5th. So I'm waiting to go to court.
for the same offense that you're here on.
And they would have it actually before this office.
Right.
And,
Judge, the state's recommendation in this case reflects certain impediments to us meeting our burden of proof and potential defenses that Mr. West may have. We're not
All right.
conceding that we couldn't be a burden if put to it. but
Thank you,
that's
Mr.
what- that's
Coleman.
why we
yes,
made the offer.
and that's. we
I
wanted to-
appreciate
we
that.
talked about that, and make sure we reminded you that there was a reason why.
Perfect. Thank you. All right, sir. I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for a period of 7 years. You're ordered to follow all of the rules and conditions of probation. And if you do that, this is a great opportunity because you don't have this conviction on your record. And if you complete the probation successfully, then at the end, this case is dismissed and you'll never have this conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you could be found guilty and facing a sentence of up to 10 years in prison. Do you understand? Obviously, you're a convicted felon. You understand you're not able to possess a firearm as part of Texas law. It is also a condition of your probation as well. And part of that is going to be for you to go get that other case taken care of as well.
Yes, me and him are talking about that other case. So it's really-
Perfect. All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up when she's ready to go over all your paperwork. All right, good luck to you.
Thanks, Judge.
Thank you. Mr. Rojas, you have Rebecca Rito, cause numbers 23 DCCR 0928 and 2106 and 2107. Ma'am, are you Rebecca Rito?
Yes, ma'am.
And Ms. Rebecca Rito, in each of your 3 cases, you're charged with a state jail felony offense of theft of property with prior theft convictions. What that means in each of those cases is that if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes, ma'am.
And I have in each of your cases here on the computer some plea bargain rejections that you've signed with Mr. Rojas that shows that the district attorney's office has made offers if you wanted to enter pleas of guilty for 18 months in the state jail prison in each of those cases that would run concurrently, which means together at the same time. You have every right to reject those offers and have your cases set for trial. I want to make sure you understand what the possible consequences are and what your options are if you go to trial. And do you understand all of that?
Yes, ma'am.
And do you want to reject those offers and have all of your cases set for trial?
Yes, ma'am.
And yes, sir.
John, I'm sorry to interrupt. I just want to point out that after today's rejection by the defendant, the state will be filing a motion to accumulate or stack these sentences in each of these 3 cases. Judge, I think they all have 3 different offense dates.
And does the offense dates make them or the conviction dates make them eligible for that?
My understanding is just so long as it doesn't come out of the same occurrence or
Mhm.
transaction.
So what that means is there's the possibility, Ms. Rideau, that the state will, sounds like the state will file, and then there would be the possibility, dependent on how I feel about any punishment, that would be left up to me, whether or not any possible punishments that you receive from a jury could be stacked on top of each other. Do you understand?
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am.
All right, we'll get that done. And Mr. Rojas, you're appointed.
I am.
Ms. Rideau, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with
Yes,
you?
ma'am.
So, Mr. Rojas, you're released. Ms. Rideau, we're going to appoint someone this morning. If you'll have a seat kind of on this side of the courtroom and watch for the clerk, she'll call you up when she can give you that information.
Yes, ma'am.
Thank you. While they're doing that, Mr. Bruce Smith on Pride Walker, cause number 24 DCCR 0784. It's a sentencing. There was an extra sheet that Kelly had on my desk. It was just a memo. Right, sir, you Pride Walker. And Mr. Walker was previously in court, entered a plea of guilty to the 3rd-degree felony offense of indecency with a child by exposure. I've received a copy of the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, sir. Yes, sir. And the addendums from statement, I believe, memorandums.
Yes.
That links.
Are there any additions or corrections other than that?
No, Your Honor.
Any reason not to go forward with sentencing?
No, not with the state.
All right, then I'm going to find, sir, that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for a period of 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Can I ask everybody, if you're talking about a case with the DA, that's fine. If not, I just got a lot going on and everybody kind of keep it down. Thanks. Okay, so defer all proceedings for a period of 10 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have this conviction on your record. And at the end of the probation period, the case will actually be dismissed if you successfully complete it. The other side of that is if you violate any condition of probation, you can be brought back into court and you could be found guilty of the offense and sent to prison for up to 10 years. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. And because it's a deferred, is there a requirement for registration? Did y'all already do that? Did y'all already fill out the registration admonishment? I don't know that I see it.
I don't remember, Judge.
I didn't see it on the tablet. Judge.
So if you'll do that before you, so you'll need to fill out another paperwork. And we talked about this on your plea. Because of the plea, you will be required to register as a sex offender. There's some information that you'll need to sign with Mr. Smith today that goes over that, and then have a seat and wait for probation to call you up and she'll go over all your other paperwork. Okay. All right. If y'all make sure and get that done, please. Mr. Bratton, in cause number 23, DCCR 1735, you're charged with failure to comply with sex offender registration requirement from August 10th of 2023. And what that means is that if you go to trial and you're found, well, hold on a second. That indictment further alleges that you were previously convicted of failure to register as a sex offender, June 8th of 2007. After that was final, you were convicted of failure to register as a sex offender, and that's August 29th of 2016. After that was final, you were convicted of failure to register as a sex offender, June 6th of 2017. And so what that means is if you go to trial and you're found guilty, you would be considered a habitual offender with a minimum punishment of 25 years up to 99 years or life in prison. Do you understand the possible range of punishment if you go to trial and are found guilty? And I have a plea bargain rejection here that has an offer that the state has made to proceed on count one only for a 6-year term in prison. You have every right to reject that. I want to make sure you understand what your possible consequences are and what your options are if you go to trial. And do you understand all of that? And do you want to reject that offer and have your case set for trial? Are you currently registered properly? Okay. I want to make sure you understand as a condition of your bond that you are obviously required by law, but as a condition of your bond, if it comes to my attention that you are not properly registered, your bond will immediately be raised and you will be back in custody. Do you understand? Also, is there any reason to believe that is there anything else you're waiting for? Any reason to think that there would be a change in this offer? So, all right, Mr. Bratton, after today, I'm not going to accept this offer. You have every right to have a jury decide and we'll get your case set on the trial docket, but I want to make sure you understand that after today, this offer will not be on the table. Do you understand? All right, we'll get it set on the trial docket.
Thank you.
Thank you. Mr. Edwards, in cause number 23, DCCR 1069, you're charged with the second-degree felony offense of burglary of a habitation from June 24th of 2023. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Vasquez?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Then it looks like the agreement that you've made is for a 10-year term in prison, but that would be probated and you'd be on probation for 10 years. You would be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
And do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Edwards is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to the probation officer before you leave the courtroom today, and she's sitting at that desk right there. All right, we'll see you back at sentencing. Mr. Matuska, you have Tina Lewis, cause numbers 22-40200 and 40201. Good morning, you're Tina Lewis.
Yes, ma'am.
And Miss Lewis is, both cases are charged with injury to a child. What's the announcement?
Your Honor, we're asking for one more announcement setting based upon the volume of records that we've been able to locate on the cell phones that the state has provided to us. These were not records that were provided to us early in the case. Ms. Lesniak had basically got those together before she left to give those to us. After meeting with my investigator over the last couple of weeks, we've been able to identify thousands of documents that we're still going through. I apologize for that, but we're doing the best job we can to get to them.
United States opposed to a reset or continuance. So in this case, the court will recall that this case was on the trial docket. And we asked that it be placed back on the trial docket. I've spoken with Mr. Matuska, and we are far apart. I don't see us working this case out. And we'd ask that it be placed on the trial docket, giving Mr. Matuska, of course, sufficient time to review those cell phone records.
Your Honor, we placed that on the trial docket prior to having those records.
So let's see. I mean, do you anticipate there's any possibility that those records will somehow change the status of the case?
Yes, Your Honor. So far, we've found multiple exculpatory information on it. I wouldn't say we didn't expect, but we were surprised by it.
Here's what I'm going to do. Let's reset it. I'm just going to do one more normal reset, 30 days. And that will be the final announcement date. At that point, everything needs to be gone through and decisions made. If there's something that gets worked out, great. If not, it'll go back on the trial docket on that date.
Yes,
Okay, thanks. Mr. Samuel, you have Christopher Wade, 24 DCCR 0264.
This is my first setting, just coming off of vacation. I've spoken with the prosecutor and we talked with him. I'd like to have one other opportunity to review this with him.
Are you Christopher Wade? What does your shirt mean? Just a graphic shirt? Probably not so appropriate for court now that you look at it.
I'm sorry.
Okay, pay attention next time to what you put on, okay? Any issues?
Not this time, Your Honor.
All right, we're just gonna do a normal reset. It's important that you stay in touch with Mr. Samuel. He'll get with Mr. Nichols, go over the case, so we can get an announcement at that next court date.
Thank you, Your Honor.
All right,
Thank you.
you're free to go. Good morning, are you Devontae Savoy? And Mr. Savoy is charged with aggravated sexual assault of a child and also tampering or fabricating with physical evidence. And what is the announcement?
Your Honor, there was some
Collection.
taken to the lab. We're waiting on results in regards to DNA.
Okay, any ideas where that is in the process?
I don't have I've contacted DPS, but it was sent to a contract lab. That's what I'm
Okay.
contacting through them.
Any
I'm
other-
not sure which one it is.
Any issues with bond conditions or anything like that that we know? Everything okay?
Everything's okay as far as I understand it.
Okay, so make sure you keep following all of the rules of your bond. I'm gonna reset the case. Let's do about 45 days.
Okay.
And that way maybe we'll see where we are. If you can get some more information on the DNA, obviously that's important for everybody.
Yes, ma'am.
And so we'll see where we get at that point. Stay in touch with Ms. Holmes and she'll let you know when you need to be back. Okay, you're free to go. And you have Jamie Story, Mr. Rojas, cause number 23 DCCR 1546.
I think we need to call his name, Judge.
I did, and I'd already filed.
No response to that.
All right, I had already found that she was at large without proper bond for not showing up for her PSI. I reset that bond to $50,000. At this point, her bond, I'm going to, again, because she hasn't also showed up to court, find that that bond is insufficient and raise that bond to $100,000. Roderick Walters, 23 DCCR 1880. Waters, I'm sorry, I'm renaming people today.
Need to call him also.
Yeah, he did call, but we've had issues each time, so.
Yes, ma'am. And I just
This bond will be forfeited for non-appearance and reset at 100,000.
Judge, if I could, on behalf of Mr. Waters, I did speak with him yesterday at length, and he told me that he had some medical issues going on. He had an appointment with MHMR, I believe, this morning. I asked him for proof of that. He said they would not give it to him until he went to the appointment today, so maybe he'll get it to me today. I don't know.
If you get that today, then obviously I'll reconsider.
You could forfeited this bond.
Before, I think this has happened before.
It was a different issue last time.
Okay, it's gonna be, then at this point, obviously, if there's some issues, if he needs help, we'll get that available, but I'm going to forfeit his bond, reset it at 100,000. If he's not in the hospital or something like that with some type of true medical emergency, then I'm not gonna reconsider that. Okay, thanks. Would you please call the name Johnny Jacobo Ramon, cause numbers 24 DCCR 1371 and 1372. Johnny Jacobo Ramon. All right, I'm going to forfeit his bonds for non-appearance in each of his cases. Obviously, I have some information regarding what these cases are. We've got an intoxication manslaughter. There were some issues where I reduced Mr. Jacobo Ramon's bond because it was required by law. I'm going to raise those bonds in each of his cases at this point for non-appearance to $250,000 in each case. Condition of those bonds in each case will be that he's required to wear a GPS monitoring device and remain in Jefferson County, Texas, as well as have an ignition on interlock device on any vehicle he's driving.
Judge, those are two separate offenses. Just to let you know, they look like they could come out of the same instance. We would also ask, just based on some information, that if he has a valid passport, that he be forfeit.
It will be a condition of his bond that he forfeit any passport as well, if he has one in each of his cases. And if you'll put a note on my desk so I can call the warrant division, please. I'll call your name. Please come forward. Shelby Basha. Good morning, ma'am. Are you Shelby Basha? Basha. And Ms. Basha, this is your initial appearance and cause number 23 DCCR 1486. You're charged with the state jail felony offense of theft of property. And that is from May 1st of 2022 and continuing through October 31st of 2022. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I've been researching one, but I haven't been able to find one.
Okay, so what I'm going to do is reset your case for about 30 days. That'll give you some time to try to get someone hired. If you get someone hired before the next court date, then bring the reset notice that you're going to get today to that lawyer. They'll tell you what you need to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me the names of the lawyers that you've talked to when you come back, so I know you're trying, and then we'll discuss what your options are. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand?
Yes, ma'am.
If you'll step in front of the clerk right here, she'll give you that reset notice. TJ Landry. Good morning, sir. Are you TJ Landry? And Mr. Landry, it looks like this is your initial appearance and cause number 24 DCCR 0165. You're charged with the state jail felony offense of theft from a person. And that's from December 9th of 2023. And since you've made bond, have you had an opportunity to try to hire a lawyer?
No, I haven't.
You did? So, good. So what I'm going to do, Mr. Landry, is reset your case for about 30 days to give you some time to see if you can get a lawyer hired. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer, and they'll tell you what you need to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me the names of the lawyers you've talked to, and then we'll discuss what your options are. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you'd have to go back to jail. You understand? If you'll step in front of the clerk, she'll give you your reset notice. Good morning. You're Michaela Collier?
Yes, ma'am.
And Ms. Collier, did you get someone hired?
Oh, my bad. I did do what you said, and I actually contacted 1 and 3. I contacted 5.
Okay.
And I currently just finally got a place because the last time we discussed, I was homeless.
Mm-hmm.
So I am getting on my feet. And I was trying to go through with the court appointed attorney.
Who'd you talk to?
Can I call the phone?
Yes, ma'am.
James R. Markin. They said $8,500 for a plea dismissal trial, another $5,000. Jason Bailey Law Firm, $15,000. Provost Humphrey Law Firm. They said they were gonna call me back.
Okay.
And the law office of Lori Perezzo,
Mm-hmm.
$3,500 and a and up, and for no child, and go to child 7,000 and up, and Douglas Law Firm 2,500 to 55,000 dollars.
Thank you for doing what I asked you. Did you get a drug patch?
No, they're not supposed to get a drug patch. Last time you came to me.
You tested positive
Yeah,
in
for
court.
marijuana, and then you told me that you were gonna drug test me again this court date.
Because you weren't working and you couldn't afford the drug patch. Is that right? Am I recalling
I
right?
just told you that I was working because I had needed to get a place because I was homeless.
But I didn't order a drug patch.
No, ma'am.
Have a seat. Let's get you tested.
Okay.
Kimberly Harris, cause number 23 DCCR 1832. But thank you for being here. I'll recall the bond forfeiture. I know you talked to your bondsman as well. Ms. Harris, it looks like this is your initial appearance. And cause number 23 DCCR 1832. You're charged with the state jail felony offense of theft of property with 2 or more previous convictions. That's from June 16th of 2023. The indictment alleges 10 prior theft convictions. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? So when you're in custody, we give you an attorney automatically. Now that you've made bond, we expect you to try to hire a lawyer. So I'm going to here's what I'm going to do. I'm going to reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, then bring the reset notice that you get today to that lawyer. They'll tell you what you need to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me the names of the lawyers that you've talked to. Then we'll discuss what your options are. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order. Do you understand? All right. Step in front of the clerk. She'll give you that reset notice.